I think coffee break has become a longer, so we have to bring the technology in it. uh, well, ladies and gentlemen, I think this is the last technical session and people have less interest, but still, nevertheless, for whoever is present here, um, luckily we have a very illustrious, distinguished panel, and the experience which this panel has, I think I can boast that presently in this area, you won't find alternative available right now here. The topic is very interesting, technology and competition law, emerging challenges. We all are seeing practically every day the technological changes taking place in economy. Largely, every day new thing comes and then we try to make ourselves familiar with that. But we don't understand many things. We only know what is the use of it or how it is being used. But the 90% hidden aspect of technology is not visible. It's only the outcome of that technology is visible, and that makes it very interesting and complex subject. And we have to struggle to understand these changes taking place in economy. Our economy is also changing very fast and technology is also changing very fast. So we have to keep pace, and you all are in this area of antitrust law mostly, I believe, and either you are practicing or likely to practice or advising the enterprises. And we in the commission and in other areas, we are also learning about this. Yesterday, I was reading in newspaper that Alibaba, there was a singles day, something like that, and in 1 hour they did 5 billion business. I think you must have also heard about this. So this is how the technology has made this kind of economic activity. 5 billion is not a small amount in 1 hour. You can imagine how much efforts or the network this technology must have made available to how many consumers or the customer to enable them to make, place their order. When they will get their item, etc., is a different issue. But you can imagine the magnitude of this, and there is an estimate that by 2020, this kind of e-commerce will have around 700 billion kind of transaction, or I can guess only that this much will be the economic effect on the economy. There are many issues involved in this, and it is not very easy area to practice in the law. Antitrust authorities are also struggling to decode the technology and see only what are the competition issues involved in it. At the face value, sometimes we find that it may be a predatory pricing case, or somewhere it may be an abuse of dominance case, or sometimes we find that there is some hidden issues involved in it, but we don't understand what are the things. But ultimately, when any new technology comes in the market, consumers are always excited about it, and they get some of the schemes. They are very encouraging for the consumers, and they get benefit of it. I 2 days back, due to this problem of bank transaction, I shifted to Paytm, and I got a message that for few transaction I will get some cashback. So I am very happy. So these are the issues now. Whether this is from the competition point of view, whether it has any bearing on with the competitor or not, I don't know. We have to understand that technology, and to decode these issues, we will have to go into detail, and try to understand various issues. Uh, since I have a very distinguished panel here and we have some of the discussion points available in the agenda itself, I won't go into detail alone, and then we will share the views, and you are also welcome to raise the issues. We will try to understand equally. It is it's a collaborative discussion actually. We don't want to impose anything on you because we are also trying to learn. This is being a new topic. I would request the most experienced and founder of the competition law in India, especially the enforcement activities, first chairperson of the Competition Commission of India, Mr. Dhanendra Kumar, sir, to cover the issue relating to the enforcement for digital economy. Should regulator wait and watch or interfere in this area at this stage, when initially in Indian market this is a new concept, though it was there earlier, but it was not affecting all the general consumers. But now every consumer is affected, and you know that today and last 3-4 days the people are struggling. ATMs are not functioning because the technological requirement. I am told that earlier 1000 note and the new 2000 note has a difference of size. So the ATMs are not accepting due to technical upgradation has not taken place. So they are not throwing the 2000 note, only 1000 note they are attuned to. So this kind of technology is affecting our life daily, and we have to go into detail of all these issues during this available time. 5:30 is the last. We will be closing it because due to other commitment. Within the limited time available and the expert panel available with, I think I would request Dhanendra Kumar sir to say some. Give his opinion and his comments on this first topic.
Good afternoon, and thank you, Mr. Bankar, for your very generous introductory remarks. In fact, Mr. Bankar and I have been colleagues when the CCI set up its new infrastructure in Hindustan Times building and initiated the enforcement. And we shared very eventful days during those days of 2009. Well, friends, let me first of all compliment you for exercising your choice in attending this session after the other choice of tea and coffee extended session, which you were there, and not everyone has exercised this choice which you have done. So my compliments and thanks to you. Let me also thank and compliment the Competition Law Bar Association. I still remember when it was set up, and I was Chairman CCI and the Competition Appellate Tribunal Chairman, Justice Arijit Pasayat. They set up this this association, CLBA. At that time it was called Competition Law Appellate Bar Association. With my persuasion, they dropped the word appellate and became Competition Law Bar Association. Idea was to have a focused bar on the competition law. And I'm so happy that they are providing a platform for this meaningful interaction between the lawyers and practitioners and the regulator. And even the regulator, CCI, is deserves compliment that they have opened themselves up for hearing various viewpoints and having this collaborative, interactive platform. Having said this, let me say a few words about the subject under discussion. Today we are living in a globalized world, and the world is changing very fast. So fast that it's difficult to keep pace with it. And I've been often saying that, but look at the examples which are there just a few years ago. Say for example, Kodak film. They were predominant players in the market with 85% share of the market in 1995, and they had 185,000 employees, 85% market of photographic paper. and 3 years they became history. Nobody uses the photographic paper anymore, and the digital photography has overtaken. Same is true of other areas as well. I mean, look at the online booking of tickets, and look at insurance, look at many other areas. And I mean, I'm just coming from USA this morning. There I went to a showroom to see the Tesla cars. And the automotive cars which are going to have the dominance on roads, they will soon make the current models and everything redundant, and you could have driverless cars. And what does that mean? That the insurance companies, the drivers, and many others, even the petrol companies, because it's all recharged, so they can become redundant. Now, the changing face of technology, how do we regulate it? You have to see that. Can you regulate such a changing landscape with traditional bullock cart regulations, so to say? You have to change your regulations and your approach to the regulations at least certain degree better than the current pace, if not aligned with the changing landscape of technology. Look at the preamble of our competition law. In the interest of economic development of India, the focus is economic development of India. You are just an instrument. And this instrument has to work in order to accelerate economic development of India. Every country has its own unique socio-economic perspective. Now look at India. In India, a larger share of its GDP is made of services sector. And within the services, the IT sector. IT is the most prominent USP of India's gross domestic product. And in that kind of a situation, and looking at the priorities, what the government of the day has announced, the digital economy, the startup India, and all that, what we are talking, the broadband and so on. In this kind of a situation, what do we do? How do we regulate this system in order not to chill the innovation, the startup ecosystem and so on? In India, we have the likes of Flipkart, Snapdeal. Mr. Bankar just now mentioned about the Chinese supergiant Alibaba, but we have a number of our own emerging Alibabas in the making, which started off with very small seed money, and they are coming up of world standard. Some of these have been evaluated at $10 billion and more. Now, many more are in the making, and the Indian entrepreneurship, and I can see a lot of young lawyers, the Indian youth, they are comparable to none in the world. So with their entrepreneurial skills, we hope to see many more startups coming. So we have to give them free flowering. We have to make sure that the competition helps them rather than chill their innovation. So in order to do that, we have to look at the way in which we would intervene. And that brings me to the question directly what Mr. Bankar mentioned, when and how the CCI should intervene. The philosophy and the effect-based impact has to be seen. We have to see the impact on the local market in India, the impact on local economy in India, and the impact on what India needs to accelerate economic development. It could be a competition in prices, competition, could be a competition in innovation, competition in quality, or competition in volume. Now, these competitive processes should bring in some good for the Indian people. And at the end of the day, competition is about sustaining competitive process, about sustaining competition and nurturing it, not about protecting competitors. If inefficient competitors fall by the wayside and the efficient competitors come up and they constantly challenge the competitors to improve their products and bring up better products, cheaper quality, new initiatives, new innovations, then so far so good, it's welcome. So in brief, I would only like to say that we should tailor our interventions in a manner and the timing in a manner that it helps competition, it helps innovation, and it helps accelerating economic development of the country. And that philosophy has to be kept in view. And we have to also see similarly what is happening in other jurisdictions. So in most of these cases, individual cases may be subject matter of litigation or whatever else in various jurisdictions. So we have to also see what is happening there. And I remember I was present in a morning session when Justice Endlaw was also here. And the point I was also trying to bring home at that point, that the focus has to be, if at all, in improving the market practices where it has been detected that there are anti-competitive market practices prevailing. And the focus has to be on consumer in that kind of a situation, not the competitor, the end consumer. So we have to benefit the end consumer and the competitive process. So without taking too much of time, I know we have a very distinguished panel and we have the number of issues to cover. I would compliment you, Mr. Chairman, for initiating it the way you did. Thank you.
Thank you, sir. Now, we know that in this sector, technology, only the efficiency is the important thing. And if any system which brings efficiency and the benefit to consumer, I think that should be the prime factor in looking into, rather than protecting the competitor or the old system of business or the economy, which we call it brick and mortar type of thing. But these things these are inevitable changes due to technological changes. These things will happen. We keep a track on it. And I think each and every issue, as you rightly mentioned, is not required to be intervened. It's only when the gross violation or something which distortion takes place in the market, then only I think regulators should interfere. But there is an economic element into this decision also, and for this I would request Dr. Geeta Gori ma'am to cover or give some comments on it, so to make the things easy for us to understand how the technology and economics works together.
Thank you, Mr. Bunker, but let me save up the economics to the end so that if they do get tired, they can wait. Because I will build up a lot more on the concept of efficiency, because that's exactly where the shoe pinches. But have you noticed something very interesting? My audience is young. Most of you are the age of my children. Huh? And here there are 3 regulators, I'm leaving out the 2 extreme, who are much younger. And so you're all the disruptive age people. I have arguments in and out, and as the regulator, we're wondering how to intervene and wait and watch. So this is what really struck me. And perhaps it is that feeling that has the regulator gone too old in his concept and ideas and not understood a new paradigm that is taking place. And this is a paradigmatic shift in the last 5 or 7 years, and you have one shift every 2 months or even quicker. So when we look at this and how we are going to assess it, I'll put this into economic terms, but it just struck me. And let me give it over back to you, Chairman, sir, and see how you want to handle.
I think before we further discuss this topic, I would request Mr. Patel to give the, how the internationally this aspect is being looked into. So then I will request Mr. Ravi to do it.
I think this is working. So I think, ma'am, you do yourself a disservice by making this about age, because I don't think that the CCI or any other agencies around the world need to be shy about considering technology markets. Technology is integral to our everyday lives. It's going to become increasingly so, and it's an important part of the economy. One should, of course, look, but I think that's consistent with the views that the US agencies and the European agencies are taking. One should look. The crunch, I think, becomes what to do, right, once you're looking, when to intervene, what practice to attack, and how to deal with the dynamic, this is what Mr. Kamal spoke about, the dynamic nature of competition, the way in which markets rise and fall and develop overnight. I think, provided agencies have that caution in mind and target the enforcement action in the right way, there's nothing inherently that should stop them. I don't propose, a personal view, that they should wait and watch, but they should intervene only when absolutely grounded in effects and when taking into account the market realities.
Sure, sir. I'll just quickly, I think everything's been covered. I think all points have been made. But if you look at the question that's been posed, the question really is, should the regulators wait and watch? So there's absolutely no question about not intervening. Nobody's, I don't think anyone's suggesting that there should never be an intervention. But if, again, I think, when you're looking at figures in the range of 700 billion by 2020, when you look at the inherent nature of the Indian IT sector, the fact is we hear of the success stories, we hear of the Flipkarts, and we hear of the Snapdeals, we hear of several others, but there are perhaps 10 times the numbers that have failed. And that is because that is the process of innovation. There is always someone out there trying to figure out the next formula that works, that clicks, that gets accepted by the population. And which is why in 5 to 7 years you have a Flipkart which has gone from nothing to $10–15 billion valuation. And I think ultimately the manner in which the enforcement happens or should happen in India, and we're clearly seeing that in the Commission in the recent past, is it's about taking an informed decision, because you have a machinery, you do not want to stress the machinery with cases that typically don't have a competition issue. And therefore the Commission has implemented, and very effectively, the system of actually filtering out complaints. So now it's almost a matter of practice for the opposite side to be called in before the 26-1 stage. And I think that is extremely important, because it gives the Commission that perspective, it gives Commission that full 360-degree perspective of the issues, and that will of course guide a decision whether or not they should intervene in a particular case, because clearly not every case requires intervention, but there will always be something that requires intervention, and getting it right is perhaps the challenge. But I think the Commission can benefit greatly from the failures of other agencies. They have the benefit of looking at Europe, looking at the FTC, looking at several other agencies who over the years have committed errors, and those errors should inform the decision making in the Commission, and I think that we're probably heading in the right direction to that extent.
I thank my panelists. They have thrown a very good light on this topic, and I personally have learned one thing, that I think the regulators are not barred to take cognizance of any issues. If they feel that there is a real issue, it has to be, because if you wait, then this technology changes so fast that by the time you wait for a few years, then the same technology may even disappear from the scene. So it's the point when the right time, right decision has to be taken and seen in the broader perspective, rather than picking and cherry picking or doing the injustice to any startup or new technology by putting some obstacle or anything. It is the free market. Whoever is the efficient, whoever is brings the better innovation or better technology, I think market will decide automatically. But in the process, If something really happens abnormal and it require regulatory intervention, I think that should not be, regulators should not be shy of this thing. We moved in this discussion point, the another point of importance, and that is that if suppose we decide to intervene, what is it? Yeah, no, I think we have decided the other one. No, not now. If suppose we decide to intervene, then what are the factors, and especially the economic factors? I think those are the important issues, and I think we should tackle those first. Then only I think we proceed in this direction to make
Thank you,
it
Banka.
easy for that.
Thank you,
And
Mr.
for
Banka.
that, I would request Dr. Geeta Gori to
I
take
thought
on
I
lead.
would end the session, but then it's good to come in between. Ruchit, the reason why I brought this age factor in is that this paradigm shift means the cases that come to the Commission are from competitors. It's never the consumer. And we have to start asking the consumer. When there's anything disruptive, it's the consumer who benefits. You have an Ola taxi, or you might have your Paytm. No one asks them. It'll be another competitor who wants to get into Paytm or into Ola who comes to the Commission. And that means we have to look at the whole shift in why it's taken place. It's disruptive, and whatever is disruptive is something that's changes are taking place which the Commission has to look in. That's the age factor I was trying to bring in. And that's why I said the arguments with my children. When my daughter says coming at 12:30 is very early, I have to accept it because that's the shift in the way it's being done. Now, I know all of you are laughing at it because these are arguments which you must be having with your mother. But coming back to the issue of the law and coming back to the issue of economics, the shifts and the changes that have been taking place in economic theory doesn't get reflected in law. And it's also because law cannot change so quickly, and there must be a whole process. You can't keep changing the act. But what I was trying to do is to be able to explain and using the concept of efficiency as to what bothers us between MRTP, CCI in 2009 and CCI in 16, going on to 17, what the changes have really taken place. And the most important thing is when the competitor comes in, or why do we talk about the competitive process? The most important thing about the competitive process is that the consumers gain. There is no welfare loss. As an economist, we look at three efficiencies. We look at the allocative efficiency, we look at the productive efficiency, and we look at the deadweight loss. So you go around saying that prices should be equal to the marginal cost because that's how the consumers gain. But again, when you go on to it, and the worry that was there always with monopolies, that they can exert market power. They can raise prices, they could reduce quantity, so you're going to be affected by a monopolist rather than competition. So what is the approach that gets translated into the law? Look at monopoly. Look at monopoly and look at any price rise, look at prices, and that means that the consumer is losing out. Intervene in favor of the competitor to bring in more number of firms. And the interesting argument that has taken place between perfect competition, monopoly, and monopolistic competition is that it is true. If you have monopoly, you don't have efficiency. You will have a decrease in welfare. But what a monopolist works is with monopolistic competition. And monopolistic competition means that the monopolist, if is to stay in power, has to keep running. The Paytm might get overtaken by someone else immediately. The changes are taking place so much more. And what is it that you're looking at when you're looking at monopolistic competition is how do you provide the incentive to any firm to invest in R&D, to invest in technology, and to invest in innovation. So that is the sort of sea change that has come up between looking at competitors, looking at consumers, and looking at monopolistic competition. So this is a good lecture of economics, which I haven't done for a long time. But I think, what is it that bothers the Commission? The concern for the Commission always is, will the monopolist use his position of dominance to prevent any competition from coming in? That's the basic worry. And the basic further worry for all of us economists is the law doesn't help you to answer that question. When you look at it in terms of just pure monopoly, even a monopolist, if he is facing a very elastic demand, that is, if prices are very responsive, if he increases his prices of his commodity too much, there'll be no consumers. That is why in the Act you have reference perhaps to price. When you define a consumer, you look at price. But then later on, when monopolistic competition started in the US, they came up with price elasticity, which is your snip test. But then combining the two of them, are they enough as key tools? Because the whole concept of price has changed. How do you define a consumer in India? How do you define a consumer anyway? It's a person who pays a price or for a consideration. But now recently, the European Commission says that data is price. That's the argument that has been given. Now, how can personal data be price? Yes, to some extent, it's a consideration. But recently, I was part of that 6 lakh people scam of ATM cards, and they told me, your credit card has been seized, because someone rang me up and told me my mother's name, my father's name, my birth date, everything. And I was so amazed, because people, when you go into a bank and you sign your KYC, that's personal information that gets used. But when you go into using any of these Paytm, or use Google, or you use Bing, or any of them, you sign an agreement, a terms of agreement and a privacy. And is this personal data the same as price? I use Paytm once and you use it 3 times a day. What is the value? Price is a value. Is it the same as consideration? I have no answers. And it gets more complicated, but all business now is matching markets. It's a question of getting into personal data and using. So price and the definition of a consumer again changes. And if you're going to use that definition of a price as even a competitor who's a consumer, then there's a lot of thinking that has to be done. But coming back again to the initial concept, how do you look at this monopolistic competition? What is it that makes a lot of difference? Because if there's dominance, what are you worried about? In dominance, you're worried that there might be a question of fixed cost. There may be a case of switching cost. There may be a case of complementarity. But this is where the wait and watch becomes important, because if there are no entry barriers, if there are no attempts to control, the market adjusts itself. And that is seen in the fact that everything is so disruptive. And if there is a dominant player, to stay dominant has to keep innovating. And if he has to keep innovating, it is only possible, the best test is price. Sometimes you pay no price at all. It may be a 0 price. So should I go back to the early concept that you must have price equal to marginal cost, similar to the cost of production regulation that's been drawn? If price is less than the marginal cost, who gains? The consumer gains. No one asks the consumer. Everyone says the competitor, how will he survive? He has to survive through innovation. Efficiency is this cycle that keeps coming, and what one looks at is this sort of gain and shifts that are taking place. Now, how does one proceed? One proceeds in a very strange way. It's a bit theoretical, because I don't want to refer to any cases that are on. How did the dominance come up? If there is a dominant player, and even if he is dominant, if you want to define dominance, how did this dominance come up? Is it on the basis of statutory conditions of the earlier public sector enterprises? Or have they created barriers? Or is it because of innovation? Second thing, I think Ruchit, you mentioned it, is this dominance sustainable? And you find that the sustainability, for every Flipkart, there are many who have died. And even Flipkart's life, God only knows how long. You know, it's just a question if they can keep innovating and coming up with ideas. For them to innovate and come up with ideas, they have to be competitive on price. They may set it at lower than marginal cost. They may set it at 0 price. That was the argument that one tried in the NSC. Because what are you looking at? You're looking at how you can manage to capture that consumer who wants to stay on and wants to get the benefit. And there are always enough number of people wanting to enter into this situation. So it's a question of, is this sustainable? Now, sustainability is not only to the firm. Sustainability is on the consumer side. Can the consumer be sustained? Will the consumer be sustained with an archaic system of drawing out money? Will the young consumers be happy with going with the earlier ones, but they prefer WhatsApp? If it's not WhatsApp, they want Instagram, and perhaps they'll even do out with it. So that's sustainability. And in this sustainability, both price elasticity and concept of price changes. And the concept of predatory pricing and saying price should be equal to marginal cost, I think one has to rethink on this whole method. Before I go on a little further on this thing, when you are trying to look at a new concept and you're trying to define a market, is it necessary? That's because the law says you have to define a market. How is the market defined? It's defined on the basis of the price or on the characteristics of the product. But with disruptive technology, perhaps you don't even need to look at the market. It's just that the law says the lawyers will have to do their job, the commission will say we'll look at the market. But one of the most beautiful things which I've been continuously quoting is the Chinese Supreme Court on the Tencent versus the Qihu, where the Supreme Court said, look, you can't define the market, but because it's there on the statutes, you define it. So just as much as technology has been disruptive, just as much as monopolistic competition and the dominance is very short-lived, the Commission will also have to reinvent itself and be disruptive. The concepts have to be disruptive, and the economic tools of analysis that one looks at and sees is changed totally. Last one, before I close, which I've saved it for a long time, because I spent about 8 years trying to convince, is this whole concept of a platform, the two-sided market. And, people have come up with multi-sides and this side and that side. You have two sides. Everything, Flipkart is a two-sided market. Everyone has a two-sided market. And then you have to identify who's the consumer there. The consumer is who uses it. And what does Flipkart do as an aggregator? He gets an advertiser to be able to sustain himself. So in the stock exchange also, that was a concept. If the stock exchange said it's zero price, it'll get its money from elsewhere, or it'll come up with a new technique. Should the regulator intervene? If the regulator intervenes, there is enough evidence to show by intervening for bringing more competition, by allowing more firms to come in, you are actually causing a welfare loss. Both productive and allocative efficiency decrease, and more than anything else, what we economists call as the dead weight loss increases. If this dead weight loss increases, it's not the consumer, it's not the producer, it's the economy which loses. And perhaps also we have to understand that in India, which is a country which is specialized completely in things which are commerce on the net, which specialization is in algorithms and mathematical models, it may be better to let them fight their own wars. But that doesn't mean to say you shouldn't have regulation. It may be necessary to have some sort of a regulation. But if that is the kind of regulation that is required, perhaps as Mr. Kumar has been telling me continuously, we have to think of other ways of intervention than just imposing a fine. So economic tools also keep changing. Even if the law doesn't change, as lawyers, you have to be able to put forward the argument, and as regulators, one has to be open to these suggestions.
Sir, would you like to say something? Yeah. Okay, now, after listening the economic point of view, you understand that how difficult this topic is. There are so many concepts in this, and they are surrounding the technology, and it is very difficult for a common man to understand in this. Sometimes they get there is a aggregators concept, there is a develop technology innovators concept, some new design is there. so many concepts in the technological sector, and they confuse the common person, and consumer is not looking into all these details, and it's very difficult also for the legal professional and the ordinary citizen. So this has to be seen only from behavioral point of view, whether it is actually making any impact in the market or not, rather than going into details of all technical details, because technical details will not lead us to understand the implications. And for this, I think international experience of Mr. Ruchit Patel will be of useful to make some comments on this.
I entirely agree with what you've just said, sir and ma'am, that the traditional framework of competition law that look at, say, abuse of dominance is to identify a market, see if you're dominant in that market, and then assess dominance, assess abuse. And in technology, this is almost redundant, and the more established world of agencies in Europe and the US almost never confine themselves to these buckets. Market definition is really a framework for assessing the behavior, the conduct. And really this is where the analysis should start with tech, because market definition is inherently imprecise. It's not scientific. There's no one right answer. And so if you get the wrong market, you can get to the wrong outcome. So actually, it's really important to start with the conduct. And that's why we look in Europe often at, three questions. Number one, is there competition in the merits? Is the impugned conduct, is the alleged conduct anti-competitive or pro-competitive? And is this pro? How do you decide? Well, one is competition on the merits. It's competition on innovation, price, quality, volume. And the other is something different to that. Secondly, what are the effects on competition? What are the effects of the conduct on the market? Are these bad, or are consumers benefiting? And thirdly, and perhaps most importantly, what is the impact on consumers? We are not here, as I think others will speak about, to protect inefficient, slower-moving competitors. We're here to protect the process of competition and to reward those who do it well.
I would just have a couple of brief comments here. As my colleague Geeta ji just mentioned, we have to see who is going to be the beneficiary of this challenge and why he is doing it. And as she said, in most cases, those cases are brought up by the competitors. Any abuse of dominance or any petition invoking the jurisdiction of Competition Commission of India generally is brought, as she said, by a competitor, and we have to see whether the impact of that is going to happen on the local market vis-a-vis the end consumer. Any abuse of dominance can, as we know, be either exploitative or exclusionary. Now, in such a situation, if the end benefit or impact is not really on the consumer, but on the competitor who is only using or abusing or misusing the existence of this body, Competition Commission of India, to fulfill his own ends, whether it should be encouraged, we have to see it carefully. So that was in response to the question whether it should protect the competitor or the competition. But I'm just, by the way, sitting here, I was thinking, looking at various hypothetical situations. While coming today to this place, I saw huge queues outside nearly every bank. All the banks falling on the way, there were huge queues of people who were trying to exchange money or withdraw money or whatever else. And I'm sure they must have been there for hours together in the morning, and every day they must have been doing it. theoretically, suppose a situation comes, somebody invents an application that on your smartphone you press a button and let's say 5,000 rupees would be delivered at your home when you go back. And the ATM machines go out of business. And the person who is manufacturing ATM machines files a case before the Competition Commission that this app, which has been brought up, is making me out of business. And please issue a stay order that this app should not be there. Otherwise, I would be ruined. Now, this is a new invention which is going to benefit the end consumer. So, should they stop it? Should they intervene? My brief point through this hypothetical example is you have to bear in mind the interest of the end consumer. What does he want? What is adding to his welfare, his convenience? And if somebody falls by the wayside in the process, so be it. Efficiency, innovation, any new product which is coming up, which benefits the end consumer, we should welcome it. And we should not stop the process, chill the process, or slow the process. That's the point I'm trying to make. Look at the process why this antitrust came into being. It came into being in 1819 Canada, first one, and then came in 1889 it came in Canada, 1890 it came in USA. And look at the debates, look at the entire genesis. At that time it was trust of some of the traders. Now we have seen it evolving. Idea was the end consumer has to be kept in sight. And globally that has been the objective. And the philosophy of antitrust or anti-monopoly or competition law has always been that. So kindly keep the impact on the local market, your own market, not outside, and the impact on the end consumer in mind. And as she said, the consumer benefit or welfare has to be kept in focus, whether it is increasing or it is eroding or being wiped out as a result of this behavior. Thank you.
I request Mr. Ravi Sekharnaya to
So just
give some point on it.
2-3 points, and this is strictly from an Indian practitioner's perspective. So I think there is clearly some amount of consensus about the whole wait and watch issue. I think the inherent nature of the high-tech sector requires a cautious approach. And once you cross that barrier, once you get into the realm of actually intervening, there is the traditional way of looking at cases, whether it's under Section 3 or whether it's under Section 4. We have, as lawyers over the years, we've done it, we have overdone it. Sometimes we have pretty much killed the analysis, the traditional Section 4, relevant market, dominant position, abuse. But I think the way we look at Section 4 in India and we look at the way in which the Commission functions, I think there is enough flexibility available within the legislation to actually look at other factors. I think the law and the purpose of the Commission, the mandate of the Commission, allows adopting, the adoption of several factors. Like one of the things perhaps that we lose sight of is conditions of competition. That when you get into a Section 4 analysis, what are the conditions of competition in an industry of this nature? And if innovation is the essence of that industry, if innovation is the backbone and the spine of that particular industry, then perhaps the analysis has to be at a very different level and not limited to the traditional abuse, the relevant market, dominant position, abuse analysis. And if in the high-tech sector, for the greater benefit of consumers, for the greater benefit of the economy, perhaps of India, innovation is the hallmark, and innovation will always remain the hallmark. It's always the next big idea. And I think conditions of competition and the benefits of innovation should perhaps be the guiding force in evolving the traditional analysis that we typically use under Section 4.
I think these are the issues. They are not only prevailing in Indian economy and our country alone. It's a global concept, and globally these things are being discussed, and the regulators, wherever required, they are intervening, or wherever it is not required, market is taking its own decision and correcting it. We move on to the next topic or the point of discussion, and that's very interesting. I think that makes some overlapping of the IPR or the intellectual property right and the high tech, because it's a part of the same concept, and we have to deliberate on this by seeing whether some intervention for the product design or the innovations which has been carried out by something, his interest to be protected, or his innovation or his design should be shared openly in a very liberal way to get maximum benefit, rather than getting a benefit only confining to the innovator only. And this is a very interesting issue, and we often come into our daily life also see, and we see that IPR holder doesn't want to share his know-how, his knowledge, and competition demands that it should be shared, and some competitors should be generated there. So we have to balance it, and for balancing we have to take a path which does not hurt any of the player in the market, and that is the interesting proposition. And I would request Mr. Patel to start with giving his comments on this topic.
Thank you, sir. Yeah, I mean, innovation really is the lifeblood of technology. You really cannot have a discussion on examining intervention in technology without starting that conversation with innovation. And, the whole panel has mentioned this, and I will reinforce it. The innovators win, and those who fail to innovate die. It's a fairly simple rule that you can see over time. And the innovators also are able to compete in other areas of competition. The innovators can compete on prices. The innovators can compete on quality, on volume, and on all other parameters of competition. So, the MySpaces of the world, the Orkuts of the world, those who failed to innovate weren't able to price discriminate, weren't able to profit maximize, and they died quickly. Those who innovate constantly, the Facebooks of the world, for example, they are able not only to compete on innovation with all the other social media sites, so they remain strong regardless of competition, but they're able to compete on other things. They're able to compete on adverts. They're able to compete effectively with search engines and various other internet-based companies. So innovation is absolutely the key parameter. The question then becomes, when an innovator develops an innovation that is useful, what do you do with that innovation? Do you, as Sir put it just a minute ago, allow that innovation to be shared among every single competitor in the market, such that there is, quote unquote, a level playing field? Or do you say, no, these are innovation markets, you have to allow the innovator to have the benefit of that innovation for at least a certain period? And just to take this outside of the context of tech for a moment, pharmaceuticals, very, very important market in India. Innovators are afforded a certain protection in the form of IPR, intellectual property rights, to protect their innovations. So the deep investments they make in the new next cancer drug, those sunk costs are paid back in kind during the course of protected competition. And this, I think, has a lot of parallels to tech. If you remove the benefits of innovation from the innovator, what happens? What happens to that person's incentives? Well, firstly, very clearly, they have no longer a very strong incentive to innovate, because they say, well, if I innovate and develop something new, I'm going to have to share it. This is almost a hark back to, what Mr. Kerr spoke about this morning, a sort of no longer a liberalized economy, but a protected state economy. So if the innovator thinks this is essentially Marxist and I'm not going to be able to share my innovations and reap the benefit of that, then those innovators will stop sharing them with India. Or they'll stop innovating, which is worse still. The other consequence of this is that the competitors will say, well, what's the point of innovating? Why bother? We know our competitor X, is going to innovate. We know we can rely on a complaint to the Competition Commission of India and a favorable order that allows us to free ride on their innovation. So let's continue. This would create the wrong incentives. And that is particularly important in tech. And it's particularly important given tech's importance to India. This is a tech-fueled economy, and it's doing incredibly well. And to remove the benefits of innovation from this economy in this country would be significantly detrimental. And I think that's why two things have happened. Why, one, the compact has been very clear that innovators should have the benefit of their innovations. Dr. Singhvi mentioned it, the ITPO case this morning. And why, secondly, the Competition Commission of India has been very cautious so far. If you look at their tech case decisions, Ola, Uber, Apple, Flipkart, the case goes on. There are a number of cases where the agency has correctly been cautious about intervening in what could otherwise distort incentives to innovate. So innovation is absolutely key here. My fundamental perspective on this is that we must protect incentives to innovate. And if we don't, we hurt ourselves only.
Thank you, Mr. Pandey. Rightly commented, and this has to be seen as a complementary, and a proper path has to be evolved in making a balance between the IPR and the competition law. I would request Mr. Kumar to make a few comments on it.
Absolutely, Mr. Bankar. There are enough laws in the country, the IPR laws, the design, patent, and so on, and the competition law on the other hand. Now, those laws and competition law, there has to be a balance. And in the competition law, there are specific provisions allowing people to reap the benefits of their innovations under the IPR, patent, design, and so on. And we have seen it around the world that it is so happening. Yet, as you rightly said, there has to be a balance. So, in order to allow the benefits of that innovation to everybody similarly placed, we have terms like friend. On the fair, reasonable, and non-discriminatory terms, you should allow them to similarly placed people to enjoy the benefits of those innovations and be able to compete. So that point is well taken. Then there was a mention about pharma. There I would have a slightly different take also, that we have to view this in the socio-economic context of a country. At a particular point of time, for instance, there could be a situation like we encountered in the case of a cancer drug, when the inventor, they raised the prices exorbitantly of that anti-cancer drug, and there was an innovation which was considered to be a copy of that initiative, and then the case came up before the concerned authorities, not the competition authorities, and they allowed that particular thing to be exploited there. So in that kind of a situation, it was based more on the socio-economic needs, which was of course resented by several people, but there have been instances in most other countries